we will be talking about the legal and policy framework for sustainable fisheries. Fisheries, as we all know, are natural resources. They are limited, they're not infinite, but they're renewable. And they need to be developed and managed in a responsible manner, if indeed their contribution to long-term economic development and the social well-being of our people are to be sustained. Very important from the outset to recognize that the laws and policies of our countries and our region operate within the context of both legally binding regional and international treaties and agreements, as well as non-binding regional and international instruments. So the UNCLOS is often referred to as the constitution of the ocean. As you know, the constitution is the premier law of our country. It established the framework within which everything else, all our other laws and policies operate. So the UN Convention on the Law of the Sea is often viewed as the constitution for ocean resources. And it's interesting because the preamble talks about the establishment of a legal order of the sea and oceans, which will promote peaceful use of the seas and oceans, the equitable and efficient utilization of their resources, the conservation of their living resources, and the study and protection and preservation of the marine environment. So this is by far the key instrument that function to guide our countries, and our countries are all parties to the agreement. But there are some other very important agreements. The fish stocks agreement that deals with management of struggling and highly migratory fish stock. But its implication is really much broader, and it has introduced some principles and standards that I suppose now are recognized as customary international laws. There's also the compliance agreement, the Convention on Biological Diversity, the Port States Agreement, which is emerging as a very important agreement, the only agreement of its type to combat and focus on IUU fishing. To some extent, some of these other agreements are actually supporting, complementing the Convention on the Law of the Sea. So the Law of the Sea and these, what I refer to as a complementary instrument, they're really establish the framework for use and management and conservation of the marine environment and the fishery resources. They establish the rights of states and the obligations of states. And the heart of UNCLOS and all these instruments really is a commitment to conservation, protection, and sustainable use of the fisheries that's available to us in areas under national jurisdiction as well as on the high seas. So it's very important that we bear this context in mind. And not all our member states are parties to the other agreements. Maybe about half are parties to the Fish Stocks Agreement. Likewise, I think about 11 are parties to the Port States Agreement. But in addition to these agreements, we have other non-binding instruments, the Sustainable Development Goals. These are extremely important, and especially goal 14 that deals with life below water, but others also. And then I have highlighted here the Code of Conduct for Responsible Fisheries, because even though it is a voluntary instrument, it is nonetheless extremely, extremely important for fisheries. And in a sense, it is not really non-binding, in the sense that a lot of the code is actually articulating, or has articulated, binding commitments from the other instruments. And in any event, some principles and practices of the code by now would have passed into customary international law. So it's a very important instrument, and I highlight this because to a great extent, these instruments are what are guiding the regional framework, the regional treaties, and the non-binding regional instruments that I would mention. Now, just want to touch on these very briefly as we move on. First, we have the 1983 Convention on the Cartagena Convention, dealing with protection of the marine environment in the Caribbean region, the wider Caribbean region, and the SPAR protocol in particular that deals with wildlife, offering special protection for certain wildlife in protected areas. Very important. But there's also the protocols dealing with pollution. Very, very important. And I think all our countries are parties to the convention. From a CARICOM perspective, the revised Treaty of Chaguaramas is critical, and Chapter 4, in particular, Part 2, Article 60, deals with fisheries in the community. The Treaty of Chaguaramas, establishing the CARICOM single market and economy, is very, very important in defining the broad legal and policy framework. It is a rules-based system that has been set up, including, of course, the Caribbean Court of Justice, because the rights and obligations that are, or many of them, in the treaty are enforceable. You can go to the courts if you think you're aggrieved, and the courts will look into whether or not your rights or your obligations are being breached. So the Treaty of Chaguaramas is a very, very important instrument. The agreement establishing the CRFM operates within the context of the Treaty of Chaguaramas. So the 2002 agreement establishing the CRFM is critical, one of the core agreement establishing the legal and policy framework, broad framework for sustainable use and management of the fisheries in the region. And I'll come back to that in a moment. We also have the Fisheries Declaration and IUU Fishing. It's a ministerial declaration addressing the long-term strategy, the roadmap for dealing with IUU fishing in the region, and also fisheries crime, even though at that time we weren't talking about fisheries crime, but to some extent it addresses it. There are also some other CARICOM policies that are important, do not directly focus on fisheries, but they touch on fisheries. The Regional Food and Nutrition Security Policy from 2010, the CARICOM Environment and Natural Resource Policy, which I think it is still, it's in its final stages. I'm not sure if it is enforced yet. And then we have the Common Fisheries Policy, which was adopted in 2014. And now we have 3 protocols under it, one dealing with small-scale fisheries, and this basically incorporates the relevant portions of the FAO small-scale fisheries guidelines into the Caribbean Community Common Fisheries Policy. So this is very important for us indeed, and we need to pay attention to it. Then we have the protocol dealing with climate change and disaster risk management. Straightforward. It's a protocol setting out again, a roadmap for addressing and the commitment for dealing with climate change and disaster risk management in fisheries and aquaculture. And more recently, we have, or the Ministerial Council adopted the protocol dealing with aquatic food as a strategic resource for food and nutrition security. And this is very important within the context of the commitment to reduce our food import bill by 25% by 2025, and addressing that massive food import bill, which also include fish and seafood. There's also the CLME Plus Strategic Action Program that was developed and approved by the countries in the wider Caribbean region. And it's important to recognize that these are instruments that we have been very, very closely involved in crafting, even though this is, um, beyond just CRFM. And of course, there are others like that. We have been partnering with FAO for example, we have a regional, wider regional plan of action dealing with IUU fishing. So what I'm giving you here is not, it is just a sample because, with the time limitation, I couldn't touch on all the decisions and the legal and policy instruments that we have developed. I really just want to use this presentation to make the point that indeed we have seen over the years significant developments. Now, these are some additional ministerial decisions and resolutions addressing more specific issues. Some are focused on specific resources, some are dealing with broader principles and measures that we need to pursue as a part of the larger commitment and framework for long-term sustainable use of the resource and development of the full potential, economic and social potential of the resources. So some of them here, the St. George's Declaration on Sustainable Use, Conservation and Management of Spiny Lobster. There have been fishery management plans dealing with flying fish, blackfin tuna, queen conch, etc. Fad fishery. We also have been working in partnership with our colleagues from Central America. So we have the CRFM OSPESCA Joint Declaration on Cooperation and Sustainable Development of Fisheries and Aquaculture, and we're now on our second joint action plan, just setting out the priority areas for cooperation. And indeed, even though there may not be a lot of activities, on these things, they're still very, very important instrument for ensuring better coordination and consultation moving forward. And like the BCLME Plus project, it involved Panama, and this is like one action that came out and was guided to some extent by this commitment. We have a regional strategy and action plan on climate change and disaster risk management, policy statement on the ecosystems approach and fisheries co-management, a policy and action plan dealing with gender and decent work in the fisheries, model legislation, protocols, guidelines, etc., dealing with SPS. Some were mentioned a few minutes ago when Peter made that presentation. And more recently, the Ministerial Council, they have been making a number of resolutions, some of which are quite important. For example, the recent resolution that was passed earlier this year dealing with abandoned, lost, and discarded fishing gear is quite an important policy instrument that sets some specific commitment regarding ghost fishing. There's also a resolution or a series of resolutions from 2021 through to 2023 dealing with fisheries crime and the Copenhagen Declaration and committing to the Copenhagen Declaration, even though it's a non-binding instrument. And most of our member states are now committed and working within the framework of the Copenhagen Declaration to deal with fisheries crime and IUU fishing. Somebody mentioned, Dr. Marsden mentioned the issue of fraud, seafood fraud. Seafood fraud is massive and we don't realize. And at the end of the day, it's an economic crime, and it's something that we have to deal with because, yeah. All right, moving on. But apart from these technical resource management, conservation measures, we also have focused on strengthening the governance arrangement. So we recently adopted very important strong policies dealing with anti-corruption and data protection, for example. And the last two that you see on the screen refers to the small-scale fishers, measures to ensure full integration and involvement of small-scale fishers in both in the policy dialogue regarding blue growth in the region, as well as in the quest to address the objective of reducing food import bill by 25% by 2025. So just some key features of the CRFM agreement and the common fisheries policy, because from a legal and regulatory perspective, these are the key instruments, and these are really fairly strong, comprehensive instrument. The objective is sustainable management and development of our resources, but also based on some strong fundamental principles that include there are 9 objectives in the common fisheries policy. I just try to cover both of them together because they are complementary instruments. But they provide a very comprehensive framework incorporating international best practices that you find in the in UNCLOS Code of Conduct and numerous other international instruments and broader regional instruments together to focus and address the special issues and challenges and objectives regarding the marine living resources. So they focus on harmonizing measures, welfare of fisheries, addressing, eliminating IUU fishing, safeguarding the ecosystem, very strong commitment to strengthening our national framework for action, maintaining biodiversity in the marine environment, proper conservation, balancing fishing capacity with the available resources, things like the precautionary principle, the ecosystems approach, etc. These are key commitments that we see enshrined in these instruments, and in some cases elaborated on further in the various ministerial declarations that we have. Let me just say, the big challenge is really implementing. Our countries, really, if you step back and look at what has happened over the past 20 years, our countries have actually done quite a lot. I think we all recognize that the legal reform is very slow in most of our countries. Nonetheless, several of our countries have upgraded significantly their basic legislation and policy and regulations dealing with fisheries, and I list some there. Some are still in the process, but it's ongoing, and this is not a complete list. But we agree and we make decisions and make commitments at the regional level, whether at CARICOM, CRFM, etc. But at the end of the day, responsibility for implementation rests primarily with our member states, and the implementation tend to lag significantly behind the commitment and the objective and the desire. And so that is something that we have to pay attention to, strengthening the capacity, providing the support and so on, to ensure that we improve in this area. And I have at the bottom there the CCJ, because the CCJ is a critical institution, and its involvement is growing. And the point is that the policies, the legislation, the commitment that we have here, a lot of them are actually enforceable in law. Of course, it depends on how the decisions are made and specified and worded in the various instruments. But at the end of the day, these are instruments that, some of them are instruments that can be enforceable through the Caribbean Court of Justice, which is overseeing the implementation of the commitment under the revised Treaty of Chaguaramas. So in concluding, we have seen significant development of the legal and regulatory framework for sustainable use, management, and conservation of fisheries in the region. I think the potential for a bright future for the fishing industry and blue economic growth is there. As we mentioned in the opening sermon, I think it is recognized. But we're dealing with very complex issues, and a lot of changes arising from environmental changes, climate change, ocean acidification, and a whole host of related challenges. So, there's a high level of uncertainty regarding what we're doing in fisheries. And so we have to pay very careful attention to this matter. One of the things that I think we have to look at is the um, lack of consensus and clarity regarding some of our objectives and incoherency in how we are moving forward. And Andre, in his comments, raised the issue about who should sit on the governance structure for the body being established under the Pro-Caribbean Plus project to, coordinate ocean governance in the region. At the end of the day, we see a tension developing, it has been there between environment and fisheries, and seem to be ignoring each other to a great extent. That cannot continue. And I know that the presentation, as Robin said, on the intersectorial committee. The point is, some of these have been established and they're working, but you're not seeing the type of coherence and coordination that you need to have common national objectives. So the challenges regarding CITES and the listing of all those marine species last year, fisheries ministers responsible for fisheries, ministers from the environment had completely different views on these matters. So moving forward, we have to build consensus, build partnership, and build capacity. Thank you very much.